this morning, both here in the room, but also I assume getting in. I think it's very chaotic outside. I'm glad to see so many of you here nonetheless. My name is Catarina Vieira. I'm a member of the European Parliament in the Greens EFA group, and I sit in the two important committees for today's topic. I sit in the Human Rights Committee and in the Trade Committee. I'm very, very happy to see so many people today to discuss human rights in EU trade agreements and EU trade policy, and I wanted to start with giving a big thank you to all the staff at ASSEDEL for all the work that they've put into bringing us together today and organizing this event. As you know, in the European Union, we are at a turning point where trade policy has become more important than ever. Tariffs and trade agreements are on the news almost every day for good reasons and bad reasons alike. 1 year ago, we were speaking about Trump's new administration and his plans to impose hefty tariffs against the EU and other economies. And we could already tell back then that we are entering an age where trade is ruthlessly used for advancing domestic interests. That could not be more true than it is today, as we are gathering in this event and we see that the Trump administration is attempting to conquer Greenland and threatening the EU with new tariffs away from the 15% flat rate that was negotiated last summer in Scotland, if we do not allow them to take over Greenland as they wish. So in retaliation for the troops of certain EU countries stationed in Greenland. So this is all pushed at the same time without any discussion, dialogue, or consent from the people of Greenland, and it does seem to be an attempt to open new mines and oil fields to benefit the American multinational companies, and of course we also see very little engagement with civil society and civil rights groups. However, our trade policy is not and should not be only about Trump and his threats of tariffs, nor about China's enhanced role in the global economy, or about our response to crisis. Here in the EU, in this political mandate, our decision makers have sadly often prioritized the interests of industry lobbies and other groups, and they seem to want to increase our trade volume regardless of the cost. The narrative of Europe's competitiveness seems to have hijacked the debate on sustainable and fair trade, words that we hear less and less these past few months, both domestically but also in our trade policy. So what is the status quo right now? We see a pipeline of new trade agreements that are coming up in this political mandate, like the Mercosur Free Trade Agreement, which was just accepted by the member states recently, although the vote for ratification will still come through this parliament in the spring. So aside from Mercosur, we also see trade agreement negotiations with Indonesia coming to an end, and the recent start of negotiations with the United Arab Emirates, which, needless to say, is a country with a very concerning track record of human rights. Many of these trade agreements will make the EU trade more directly intertwined with countries that repeatedly engage on human rights violations. Not to mention also, linked to human rights, the environmental and social impact of ratifying trade agreements, especially if they don't have strong safeguards. In exchange for market access, there will be a considerable risk of increasing environmental destruction in our partner countries. So while the EU is actively seeking to intensify trade relations with other partners, we're witnessing how this new narrative is quite contradictory with upholding universal human rights in the EU's existing agreements. I think at this point it's also important that we don't forget and we don't stop talking about the ongoing genocide in Gaza and the settler violence that we see in the West Bank. Israel, our trade partner, is in direct breach of Article 2 of the EU-Israel Association Agreement, which is a binding obligation to respect human rights and democratic principles. Yet, we seem to have failed to withdraw Israel preferential trade benefits despite of these flaws. In northwestern Africa, talk about neglecting the Sahrawi people in West Sahara, particularly within the EU-Morocco trade agreement, which will be discussed more in depth at the end of this session. These actions are good examples of breaching human rights obligations in trade agreements as well. So while new trade agreements are popping up in the name of European competitiveness, the EU is weakening its own legal instruments to uphold human rights. And here I'm very concerned with instruments that are not part of trade agreements, but work together with trade agreements, like, for example, the human rights due diligence law, which was recently simplified. And this was a law that was designed to keep multinational companies accountable for their supply chain. And it's now very much a shell of what it used to be, with much fewer companies being under the scope and with the obligations being simpler than what they used to be. The measures to address and compensate for harm and to prevent grave human rights violations like child labor seems to be less meaningful to the EU now than it was when the CSDDD was negotiated just a few years ago. Now, this all seems quite negative, but it is also clear that the EU does need trade and does need trade partners. The single market makes us a big global player, and countries will continue to want access to this market. There means an opportunity that trade policy can be used positively as a leverage, as a way to increase respect for human rights and promote sustainable development. However, this also means that we should not be intensifying our trade relations with countries in a race to the bottom and ignoring binding commitments to uphold human rights and international law. In this very challenging time, the EU should be at the forefront of defending the principles that are the reason why the EU was founded in the first place. It's therefore essential that we keep policymakers accountable and build on strong obligations to uphold human rights in the EU trade agreement, and that's what we're going to hear about today. I don't want to see the EU give a free pass or water down our commitments on human rights because of our trade goals. These two things should go hand in hand, they should not be a competition. So I hope that this event will give all of us a better understanding about the tensions between international trade agreements and human rights obligations, and how can we do our best to make sure that these things go hand in hand. Today we'll have an excellent group of speakers who will make 5 interventions about trade agreements and human rights. First, about legal and normative foundations of trade and human rights. Second, about the enforcement and double standards. Then we'll have a case study about the EU-Morocco trade agreement and the Western Sahara. And we will also zoom out to the UN framework and how the UN addresses human rights on trade policy. Lastly, we will conclude with a discussion about the future of ethical trade. Is it realistic or is it just rhetoric? So for now, I'd like to pass the panel to our excellent moderator from ASSEDEL, Gloria Laurado, hope I'm pronouncing it correctly, who will introduce you to the rest of the speakers, moderate, and then I'll meet you again in the closing remarks. Thank you very much.
We're very grateful to be once more organizing an event at the European Parliament, and as an NGO based in Strasbourg around human rights, it is for us very important to be covering such important topics. And I am honored to moderate this event together with my colleague, Edo. And we would start with our first speaker, which is Professor Alain Hervé. He's Professor of the Public, Economic and European Law at Sciences Po Rennes and holds a Jean Monnet Chair in European Union Law. He's also Director and Head of the Master's Program in Europe and Global Affairs and a member of the Scientific Council of French Customs. His research and expertise lies at the intersection of law, economics, and politics, fostering dialogue across disciplines. He's an author of several reference books and numerous articles on European law, the Green Deal, and EU trade policy. Thanks so much.
Many thanks, Gloria, and many thanks for inviting me here. I will speak about trade agreements and human rights, and if you could please show us, I prepared a PowerPoint presentation, so maybe we can go directly to not the following slide, but the other one. After that, there is a map with EU trade agreements. It doesn't work. Okay, it's a shame. So I wanted to show you, to start, a map of the current EU trade agreements in 2025. You can find it on the European Commission website. So my first point is I would like to stress that the EU trade agreements, there is an evolution of those agreements. Those agreements were negotiated in the 90s or 10 years ago, 5 years ago, and you have always an evolution of the provisions. Regarding human rights, I would say that the first agreement, including strong provisions on human rights, date from the end of the 90s. Especially, you can show the slide after the map. Just after, the agreement with Tunisia. I took this example in 1998. Article 2 of the agreement says the following: relation between the parties as well as the provision of the agreement itself shall be based on respect for human rights and democratic principles, which guide their domestic and international policies and constitute, that's important, legally, an essential element of the agreement. That's important because in international law, when you say this clause is an essential element, that means under international customary law that there is a possibility to suspend or to denounce the agreement if this provision is not respected. So this wording is pretty important indeed. Can you just come back? No? So this is a statistic. I've looked at all the trade agreements yesterday coming here, and I thought that would be interesting to have some statistical elements. So I just took the example of the FTAs, because you have other trade agreements, cooperation agreements, but regarding the FTAs currently in force, approximately 39 FTAs between the EU and 72 third countries. FTAs where the respect of human rights is an essential element, you have 28 agreements, so 60 countries. It's pretty much indeed. With a clausula that is the same than the one we just saw with the EU-Tunisia Association Agreement. However, some FTAs only mention human rights in the preamble, so that only means that human rights is important, but you have no essential element clause in the agreement. This is the case for 5 agreements, and in these 5 agreements, all agreements were negotiated with countries in Asia. That's the case with Vietnam, with Japan, with Korea, with Singapore, and there is an exception, which is the CETA concluded with Canada. In the CETA, there is also a clause that is not an essential element. Finally, you have FTAs without any reference to human rights. That is the case with 4 countries, and all these countries are Europeans. Mostly all-gen agreements, for instance, agreements with Switzerland, Norway, and that's normal because those agreements were concluded in the 70s. But you can see that there is no clause on human rights with the UK. So that can be explained by the fact that we think that the UK will respect human rights, and so there is no problem with the UK, but it's a kind of double standards that is a bit disturbing from my point of view. Now, if you can put the slides before, so in these agreements, it is also said, as in the agreement with Tunisia, that if there is a problem with human rights, the parties may take appropriate measures. In the selection of measures, priority must be given to those which least disturb the functioning of the agreement. So the wording is a bit, ambiguous. It is not really said that when there is a strong violation of human rights, there should be a suspension of the agreement. There is the preoccupation not to disturb trade, and we can see this tension between the human rights consideration and trade consideration. Now, when we speak about human rights in trade agreement, I think it's not enough to look at this provision, because in my view, you have other aspects of human rights that are dealt within trade agreements, especially within the sustainable development chapters. If you can go to the slide after, the one which is just after, I took the example of the agreement that was concluded with Vietnam a few years ago in 2019. So in this new generation of trade agreements that were negotiated by the EU after the Lisbon Treaty. There is a chapter on trade and sustainable development. And within these chapters, you have provision on social rights and environmental provisions also. It's interesting to look at the provision on social rights because there is a reference to ILO declaration and ILO instrument, especially those core convention on social rights from the ILO. So you can find the freedom of association, the right to collective bargaining, the elimination of all forms of forced labor, the effective abolition of child labor, the elimination of discrimination in respect of employment and occupation. So you have the reference to those principles, and also if you can show the slide just after, for instance, this is the case of Vietnam, there is a commitment to make efforts towards ratifying those ILO convention. When you look, the case of Vietnam is interesting because before the signature of the agreement, Vietnam, if I remember well, just signed 3 of these 8 ILO core convention, and after the signature, it ratified and signed 6 of the 8 ILO convention. And the same can be said for Japan and also Korea. There is a before and an after conclusion of the FTA when it comes to social rights and ILO core conventions. However, there is a limit to those mechanisms because it's only law, it's only legal provision, and there is, of course, the problem of the implementation of those provisions. If you can go to the slide that is just after, yeah. So basically, the effectiveness of human rights provisions depends on the political will of the EU institution. You have a provision in the treaty, which is Article 218 of the treaty, paragraph 9, that says that the Council, on the approval from the Commission or the High Representative of the Union for Foreign Affairs and Security Policy, shall adopt a decision suspending application of the agreement. Basically, this is the procedure applicable at the EU level, so there is no automaticity when human rights are violated by a trade partner of the suspension of the agreement. It needs the political will of the institutions, of the EU institution, and it needs to follow this procedure. Basically, the Commission will propose the suspension, and then the member states within the Council will approve or not approve the proposal. It's important to insist on the fact that the European Parliament have no words, no say in this procedure. When it comes to social provisions, there is a special mechanism, a special dispute settlement mechanism when it comes to trade, sustainable trade chapters, and it is, I would say shortly, a non-binding mechanism. There is only a recommendation that can be adopted by a panel that is composed of experts of the issue, and after that, there is no possibility of trade sanctions in most of the agreements, to be short. So the problem is the effectiveness and the applicability of those provisions. And if you can go on the slide after, I just took the example of this proposal of the Commission that dates from September regarding the suspension of certain trade-related provision of the agreement between the EU and Israel. It was proposed in September, but still not adopted by the EU Council. Apparently, there is no qualified majority for that. Several member states are against the adoption of this provision, despite the situation in Gaza that you recalled earlier. And you can go to the final slide. I just took the example. There is one panel of experts that was constituted under Sustainable Development chapter regarding the EU-Korea free trade agreements. The report of the panel experts said that South Korea violated labor rights when it comes to the right of association and the right to union. But after the situation, after this report, the situation basically didn't change in Korea, apparently. It's another problem. There is no monitoring from the Commission.
And this is a very good bridge to start a little bit more looking at the specific cases of trade agreements. And we will continue with Mrs. Lynn Boylan. She's MEP in the member of the Left Group in the European Parliament representing Ireland. She's chair of the Delegation for Relations with Palestine and a member of the Committee on International Trade, where she actively works on human rights issues within the European Parliament. Thank you so much.
Thank you, and apologies for arriving a little bit late. As you said, I am a member and Left coordinator on the INTA committee, and I spent a lot of the time on that work examining how EU trade policy intersects with upholding human rights and international law. I think it is important, and maybe some of the previous speakers have touched on this, just the founding principles of the EU coming out of the Second World War were all about human rights and multilateralism, and that, you know, not only were we going to, I suppose, as a bloc, work under those values, that then when we went out onto the international stage was the idea that we were then, I suppose, try and encourage others to uphold the same values. But I think now, as we've seen, and in my role both on the Trade Committee but also as chair of the European Parliament Delegation for Relations with Palestine, we can see that the EU has certainly shifted away from associating trade and human rights, or with upholding human rights, certainly in its trade. We have on DPAL held a number of sessions on how trade with Israel is a form of complicity within the genocide that is taking place in Gaza and the annexation of the West Bank, and also just reminding the EU that they are the largest trading partner and are accounting for 32% of Israel's total trade in goods. Excuse me. But also, and we've done this on the committee with Catarina as well, and that those sessions tend to get very, very heated within the Trade Committee. But we have also reminded the EU that it's not just, I suppose, facilitating trade is complicit in the genocide, but also that Article 2 of that trade agreement is supposed to ensure that the parties to that treaty uphold human rights. And it's very clear that that hasn't been the case, and that the EU has made clear that human rights and democratic principles are not an essential element of the trading relationship, despite the 2024 ICJ advisory opinion and despite the review of the association agreement. So all of the evidence is out there, and yet the EU continues to, I suppose, just turn a blind eye to what's happening and to refuse to actually take any actions. But I know I was sort of specifically asked today to focus more on the element of Western Sahara, because I am the standing rapporteur for the Maghreb region in the Trade Committee. And I have been looking, I suppose, at the amendments that have been proposed by the EU-Morocco agreement following that landmark judgment on the Court of Justice of the European Union in October 2024. We know that there was very specific demands within that European Court of Justice ruling that the European Commission needed to do to be compliant, and what the EU has come forward with. So first of all, we had stonewalling effectively from the European Commission, that there was nothing happening, with no updates on it. The negotiations were paused, and then all of a sudden there before Christmas we were told in the monitoring group that the agreement had been agreed in 10 days, I think. They managed to pull together an agreement with Morocco, and that they had addressed the rulings of the ECJ. And it's very, very clear that they haven't addressed what was in the ECJ ruling. So what the Commission is proposing is, first of all, they didn't consult with the Polisario Front at all, despite the fact that the Polisario Front, according to the Court of Justice, is the privileged interlocutor, and according to the UN Council Resolution 658, are actually the legitimate representative of the Sahrawi people. So while one of the concerns with the European Court of Justice was about the consent of the Sahrawi people, the European Commission are telling us that they've addressed the concerns of consent, but they haven't actually spoken to the official Polisario Front, who are supposed to be representing the Sahrawi people. And instead what they're looking at is implicit consent to address this. So as we said, there has to also be, from the Court of Justice ruling, I can never get this right, a tangible benefit for the Sahrawi people, which does not give rise to any obligations for them. So when questioned, the European Commission on this, what would be the tangible benefits to the Sahrawi people, they're effectively saying that they're going to invest in irrigation, they're going to invest in renewable energy, they're going to invest in combating desertification, that they're going to invest in water desalination, and that's all in line with the policy principle of sustainable development. But effectively what they've also when questioned was if they're going to do that, but they're going to do it for the entire region that includes the occupied parts, well therefore then there is a tangible benefit, but the tangible benefit is to the occupiers. So effectively we're rewarding those who are illegally occupying territory by investing in the infrastructure of that territory. And then the investment, what that focuses on, whether it's desalination, water irrigation or desertification, is to maximize the agricultural output of that region, which of course is not sustainable, but is also an unfair competition for farmers within the European Union as well. So there's no differentiation, as I said, so this will reward the occupiers. The other area that again calls into question serious judgment of the EU, or just questions that are standing up to Morocco as an illegal occupier of the Western Sahara, is the fact that rather than labelling the products as from Western Sahara, they're going to create these regional labels which are not recognised in the WTO. It sets a new precedent from the EU to get around labelling the products from an illegal occupation. They're creating these regions, which are regions that have names that are similar to other parts. So there's similar regions in Egypt and Tunisia, and what they're saying is that will allow EU citizens to buy products and know whether or not they're coming from Western Sahara or whether they're coming from Morocco. But of course, no citizen is going to be able to tell what this region means. I mean, you ask anybody on the street, they wouldn't know where it comes from. But it shows you, I suppose, just the attitude of the European Commission and how they have been very inventive in ways to try and work around the European Court of Justice and turning a blind eye to the human rights violations that we're seeing there. There's also a shift in that they've also linked the trade deal to the humanitarian aid in the refugee camps in Tindouf, which again violates international law, because the humanitarian aid funding shouldn't be subject to trade policy. It should be completely separate. So again, they're compromising their human rights obligations there. So as I said, we should be, as members of the Trade Committee and as MEPs, upholding human rights, upholding international law, but certainly when it comes to certain areas, such as whether it's with Israel, whether it's with Morocco, we're prepared to compromise those human rights and international law on the basis of trade policy. And I think this is what's led the EU now into a very difficult position when it comes to speaking on any international situation or geopolitics, is because we haven't set out for ourselves a sort of consistent, credible positioning that aligns with international law and aligns with human rights and is applied equally. And if you don't do that, you create these landmines for yourself, because at some point there's going to be a situation where you're compromised, and we're seeing that now in what's happening in all of the situations, including in Greenland, is that the EU, because it has cherry-picked which bits of international law and human rights it applies, has landed itself in a situation where it becomes kind of difficult for it to criticise other countries' actions. So I think that for all of us, well, not just that it's the right thing to do when it comes to upholding the obligations under international trade, it also protects us. Particularly, I come from a small country, a neutral country. We really rely on international law, and I think that this is why we absolutely need that consistency within the EU, and it's inherent in all of us as MEPs to ensure that we continue to remind them of their obligations, but also take a consistent approach to international law and human rights, and then at least you avoid these minefields if you're consistent.
Thank you so much for this reflection and also portraying a little bit the tension between human rights and the profits and international law that we see in today's European Union's trade agreements, with the specific case of the Israel-Europe Association Agreement, but also with the agreement between EU and Morocco. And also the tensions of the different European institutions. What is the role of the European Commission? What are the tensions? And this leaves a lot of open questions, which we can go back after in the debate. And I would take now the opportunity to introduce our next speaker, Mr. Omar Mansour. He is the ambassador of the Sahrawi Republic, responsible for Europe and the European institutions, advocating for the protection of human rights in Western Sahara and in promoting respect for international law. He's a former minister of the Sahrawi government and a founding member of the Polisario Front, the movement representing the Sahrawi people in their struggle for self-determination. Please.
Yeah.
Yes.
Thank you very much. Thank you, honorable members of the European Parliament, distinguished representatives of European institutions, ladies and gentlemen. Allow me at the outset to thank you for the opportunity to address this conference here in the European Parliament, a space that symbolizes the European Union commitment to democracy, legality, and respect for fundamental rights. I speak today as a representative of the Frente Polisario, the international recognized representative of the Sahrawis, the Sahrawi people, on an issue that lies at the very heart of today's agenda, the relationship between trade policy, human rights, and the rule of law. Western Sahara is not a matter of interpretation or political narrative. It is a non-self-governing territory under the responsibility of the United Nations. Its people hold the right to self-determination that has been reaffirmed for decades by the United Nations, by the International Court of Justice, and very clearly by the Court of Justice of the European Union. This legal status is not symbolic. It has concrete consequences for how the European Union must conduct this external economical relations. The jurisprudence of the Court of Justice of the European Union has been consistent and unequivocal. Western Sahara is a separate and distinct from Kingdom of Morocco. Consequently, no agreement concluded between the European Union and Morocco can be applied to Western Sahara unless the free, genuine, and explicit consent of the Sahrawis has been obtained. This principle is neither new or ambiguous. It is firmly anchored in the international law and in European law itself. It is essential to underline that the consultation is not consent. Socioeconomic impact assessment are not consent. Engagement with the Moroccan authorities, local council established under occupation, or economic operator is not consent. The court has made it clear that only the people of Western Sahara, through their legitimate representative, can express such consent. Any alternative approach amounts to illegal fiction. Despite this clarified, the EU-Morocco agriculture, fishery, and broader trade agreement have in practice included products originating from Western Sahara and facilitated the exploitation of its natural resources. Preferential access to the European market has been granted for agricultural goods cultivated on the Sahrawi land and for fish harvested off the Sahrawi coast, all without the consent of the Sahrawi people. This reality stands in direct contradiction with the court ruling. These agreements are often presented as technical instruments designed to promote economical cooperation and stability. However, their impact is not technical. It is profoundly human. They affect land use, access to the resources, employment conditions, and the daily lives of population living under occupation and without political rights. The economic benefits generated by this agreement accrue overwhelming to external actors, while the Sahrawi people remain excluded from decision making and deprived of meaningful benefits. From a human rights perspective, this situation is deeply troubling. The right for self-determination is not an abstract principle. It is a foundational human rights. The permanent sovereignty of the people over their natural resources is not optional. It is a legal obligation. When trade agreements ignore these principles, they risk transforming economic cooperation into a tool that entrenches an illegal situation rather than alleviating it. Allow me to be clear and precise. This intervention is not directly against cooperation, nor is it against attack on any state. It is a call for coherence within the European Union itself. The difficulty we have today is that the Union's highest judicial authority has spoken with clarity, while political and administrative process continue to search for ways to proceed as if that clarity did not exist. This creates a serious institutional contradiction. If the European Union expects its partners to respect the rule of law, it must demonstrate that the respect internally and externally. Judicial authority cannot be selectively applied. Human rights laws cannot compensate for the absence of legality. And economic interests, however significant, cannot override binding legal obligation. Recent attempts to revise, relabel, or repackage trade agreements without addressing the fundamental requirements of the Sahrawi consent raise serious concern. Such approaches risk undermining not only the authority of the Court of Justice, but also the credibility of European Union as a normative actor committed to a rule-based international order. The position of the Sahrawi people is clear, reasonable, and strictly legal. We do not seek preferential treatment, nor do we oppose cooperation as such. We ask that the European Union fully respect the ruling of its own court, that Western Sahara be excluded from EU-Morocco agreement unless the consent of its people is obtained, that the origin of products be transparently and accurately labeled, and that trade policy be aligned with the practice with human rights commitment. Ultimately, the question before us today is not whether trade is important. It is whether trade can be pursued at the expenses of law rights and institutional credibility. The Sahrawi people ask for nothing more and nothing less than equal respect under the law. The European Union is to remain a global reference for human rights and the rule of law. It must ensure that its trade policy does not contradict its own legal order. The credibility of EU external action depend on this coherence. The rights of the Sahrawi people required it. Thank you for your attention, but we appeal not to have double standard when you have treatment of concerning European countries or European people is different than we are treated question referent to places like Western Sahara or any place in the third world. Law is indivisible. And all of us, we are humans, and we should be treated on the same way. And the question of Western Sahara is not a question of treating a group of persons. The problem is you are neglecting all the Sahrawi people. And not only for a few days, but since 50 years, we are waiting for the respect of our right of self-determination and respect of our natural resources. And respecting that your friend, Morocco, respect the flood of resolution of the United Nations concerning Western Sahara, the right of people of Western Sahara, the Republic, the Sahrawi Republic, which is member of our regional organization of African Unity. It's not a question only of resources, but there is a war which is imposed by Morocco since 1975. Imposed. There are 1,000 of victims, Sahrawis victims of this war. And the European Commission still just treating us as a trade question with Morocco. The borders of Morocco are very clearly established. Morocco in Western Sahara is not an administrative power. It's an occupier. And the occupation doesn't generate right. Morocco is an occupier in Western Sahara. And there is no resolution which recognizes to Morocco the right of staying in Western Sahara or of trading with the natural resources of Western Sahara. This is a shame. This is a crime against the people of Western Sahara. In the place of helping the Sahrawis to the self-determination, you are stealing to the Sahrawis their resources and using it for the continuity of war against the Sahrawi people. Yes, we are doing something for the people who are in the coast of Western Sahara. Who's that people? Those are settlers, Moroccan settlers in Western Sahara, Moroccan occupiers in Western Sahara.
Yeah, thank you.
For the Sahrawis, nothing.
Yeah.
Thank you very much.
Thank you so much.
Excuse me.
No. Indeed, it was needed to say those words. This also reminds us about the need to the commitment to uphold human rights and also the democratic values that are so highly valued in the European Union. And this brings us to the questions of double standards, of contradictions, and at what cost do we do all these trade agreements? This, again, it's food for thought and later for the debate. And this was very insightful, so thank you very much. And what I take away is what Mrs. Omar Mansour said. We need coherence in the European Union, and this is a call for that, especially in European trade agreements. So now I will continue with our next speaker, Hélionor de Anzizu. She's a senior attorney at the Center for International Environmental Law and a PhD candidate at the University of Paris, Panthéon-Sorbonne, and the University of Geneva. She brings expertise in environmental law, human rights, and international trade, and is regularly invited to provide technical advice in key environmental processes at the World Trade Organization, including dialogues on plastic pollution and the fossil fuel subsidy reform initiative. Hélionor has also contributed for international treaty negotiations, playing a central role in integrating trade considerations into the ongoing negotiations for a treaty to end plastic pollution. She combines practical hands-on experience with rigorous academic research, binding policy, law, and science. Thanks so much.
Thank you, Gloria. Thank you so much for the invitation. It's a real privilege to be here and to discuss human rights and trade agreements, and have the opportunity to hear also from this distinguished panel. The words of previous speakers really show us the reality of human rights in trade agreements. And for my intervention, I would like to add to the discussion two reflections that are not specific to any agreement, but a little bit more transversal, with the hope to give you a little bit more elements to finally end up convincing you of the importance of including human rights provisions in trade agreements, if yet you need a little bit more elements. But I think you probably at this point you're already convinced of the importance of this topic. And the 2 points that I'm going to reflect also come quite a lot from what Gloria was saying of personally having worked with diplomats in the context of treaty negotiations, and it's a little bit more distilled for thinking around what are 2 key points that we have to think when we look at human rights in trade agreements. The very first point I would say is that trade liberalization can improve human rights. I will come back to that, and I think it's important because in many contexts I have heard human rights have nothing to do with trade and how we should integrate those elements. But the first point to try to bring a little bit more a positive note is that trade liberalization can also improve human rights. However, it's unconditional trade that puts human rights at risk. The main aim of trade agreements is to increase trade and market access by reducing barriers to the cross-border exchange of goods and services, which in practice, it can foster economic growth and employment. It can provide access to market for small companies or even communities that maybe do not have the opportunity to export their products. It also can contribute to poverty reduction and improve living standards. And all of those elements are essential conditions for the effective enjoyment of many human rights, including economic and social rights. However, without some form of conditionality, trade agreements can also facilitate or incentivize the production, use, and import into the EU of products and services that put human rights at risk or are embedded in broader patterns of human rights harm. And we have heard from previous speakers more examples on how that plays in reality. And here, even though the EU has domestic tools to limit imports of products that are somehow linked to human rights violations abroad, such as, for example, the EU forced labor regulation or some discussions also in the context of EU deforestation, human rights provisions in trade agreements serve as a complementary and have a distinct purpose that what you will have through directives by creating obligations and a leverage at the level of states. So in other words, directives apply internally, and the EU can decide perhaps not to import certain products, but trade agreements apply at the same level between states. So that's a very important element. Which brings me to my second point. Linking trade and binding human rights obligations gives the EU a concrete source of leverage to promote and protect human rights, the rule of law, and democratic standards globally. And particularly, as we heard as well, in today's geopolitical landscape, where democratic institutions, the rule of law, and human rights are under increasing strain in many countries, this is particularly relevant. And here I would say that this manifests in 2 points. The first point, from a more diplomatic point of view, is that during negotiations, the EU can push access to trade benefits to commitments to uphold human rights. And we heard also here from Professor Hervé that in EU practice, this usually is done through what was called the Essential Elements Clause, that is included through political framework agreements or directly within free trade agreements. But, think that during negotiations, the fact of bringing back the issue of human rights in treaties, at least in my experience, it is also an important element to keep pressure for the reciprocating country to also fourth, it is also something that we should not forget that EU citizens care more and more because it's linked to ethical supply chains. Fifth, it is also a tool that if it's introduced, it can be applied and the situation in the corresponding country deteriorates, you can activate that tool. So you better get it inside to be able to use it later if you need. We will come back to that. I know that trade restriction is not necessarily one of the actions that has been taken so far, but still it's better to have that tool than not to have that tool within an agreement. And let's be honest, at the end, the reality is that the world speaks the language of trade, and this is what we're seeing also across the ocean. So why not to include those elements within trade agreements? So the second point I would say is that once a trade agreement is in force, human rights clauses give the EU leverage to push partners to ensure that production, consumption, and trade practices respect human rights. They offer a recognized framework to raise concerns, trigger consultation and monitoring, and when necessary, justify proportionate measures, including the suspension of trade benefits in some cases, which I know is a tool that, as I was saying, is not really used, but somehow in terms from a legal perspective, it has some meaning. So it's important to remember that. So in conclusion, I would like to leave you with two messages on my end. First is that human rights are a powerful leverage in foreign policy and diplomatic relations. And the second point is that they give the EU a tool to address fundamental issues politically and legally when situations become critical and necessary. But this power only works if the EU continues to ensure that human rights remain central to trade negotiations, with new agreements actively incorporating clear and binding human rights clauses. Thank you.
Thank you so much. And now I'm going to introduce our next speaker, Mrs. Pichamon Yeopantong. She's a member of the UN Working Group on Business and Human Rights with a focus on the Asian Pacific region. She's also head of research and associate professor at the Center for Future Defense and National Security at the Deakin University. She brings expertise in business, human rights, security, and investment issues, and advises a wide range of civil society organizations, NGOs, and government bodies. We will have the connection online. So, can you hear us, Mrs.
Yes, I can hear you loud and clear.
Okay.
Now, as a member of the UN Working Group on Business and Human Rights, I would like to briefly introduce our mandate for those of you in the room who might not be so familiar with the work that we do. The working group is composed of 5 members from different regions of the world and trusted by the UN Human Rights Council to promote, implement, and disseminate the UN Guiding Principles on Business and Human Rights, or the UNGPs. These guiding principles, unanimously endorsed by the Council back in 2011, articulate the duty of states to protect human rights, the responsibility of all businesses to respect them, and the need for access to effective remedies when harm has occurred. Today's discussion really reminds us that trade is not merely an exchange of goods or of capital. Many of the salient points made by preceding speakers resonate very much with my own. Fundamentally, what we must bear in mind is how trade is about people. Workers, farmers, indigenous communities, families, in essence, rights holders whose lives are shaped by the terms and impacts of trade agreements. While trade policy is treated as an economic instrument, and understandably so, for the EU in particular, it should also be viewed as a projection of the EU's identity as a community built on human dignity, democracy, and the rule of law. Over the past 2 decades, if not more, I would say that the EU has taken important steps to integrate human rights into its trade frameworks, alongside its broader commitment to ensuring that its external economic policies align with its core values. Yet, as we know, the real test lies not only in the inclusion of human rights clauses or provisions, but equally in their implementation and in the consistency with which they are applied. This is where the guiding principles, or UNGPs, offer a useful and authoritative standard and lens. They remind us that human rights due diligence is not a box-ticking exercise, but a continuous process of identifying, preventing, and addressing adverse human rights impacts. And they also remind us of something that the working group has repeatedly emphasized. States must ensure coherence between their trade, investment, development, and human rights policies. These domains cannot operate in silos, because when they do, the result is policy fragmentation, weakened protections, and trade-offs that fall disproportionately on at-risk and marginalized communities. The working group has also stressed that trade incentives should never undermine human rights, including environmental protections. This is particularly relevant for the EU as it negotiates new agreements and modernizes existing ones. Preferential market access, tariff reductions, and investment protections must not come at the expense of rights holders, including but not limited to workers, migrant workers, indigenous peoples, and minority groups, among many others. Instead, they should reinforce the EU's commitment to responsible and sustainable trade. Similarly, it is important that at a time when the EU is seeking to strengthen its global competitiveness, competitiveness itself should not become a justification for lowering standards or sidelining human rights considerations. If the EU is to lead on sustainable and values-based or responsible trade, it must resist pressures, both internal and external, to dilute its commitments in the name of economic advantage. A race to the bottom on rights is not competitiveness, it is short-termism that ultimately undermines resilience, trust, and long-term prosperity for all. Another message from the working group that I would like to share with you here is that economic diplomacy must also align with the UN guiding principles. Whether through trade missions, investment promotion, or bilateral negotiations, states must ensure that their economic engagements do not facilitate or legitimize human rights abuses or violations. This is especially critical in conflict-affected or contested regions where the risks of contributing to harm are clearly heightened. The EU-Morocco trade agreement and extension to the disputed Western Sahara illustrate the complexities that arise when economic interests collide with international law and the rights of affected peoples. At the same time, the EU must also guard against the growing weaponization of trade. Around the world, trade measures are at risk of being used as tools of geopolitical pressure, often with profound human rights implications. Preventing further weaponization requires strengthening multilateralism, ensuring transparency in trade measures, and grounding EU trade policy firmly in international law and the guiding principles. A principled approach to trade is not only ethically necessary, it is strategically sound in an era of rising global volatility and uncertainty. The EU's evolving regulatory landscape, including the Corporate Sustainability Due Diligence Directive, despite its dilution, and the forced labor ban, signals a broader shift toward embedding responsible business conduct into the fabric of European trade. These developments in turn reflect the growing recognition globally, including in regions like Latin America and the Asia Pacific, that respecting human rights is not only an ethical imperative, but also a strategic necessity for sustainable and resilient economic relations. But of course, as we've already heard, challenges remain. Across the EU and partner countries, we continue to hear concerns about capacity gaps, uneven enforcement, and the risk of double standards. Some trade agreements contain robust human rights provisions, others do not. Some include monitoring mechanisms, whilst others lack meaningful avenues for remedy. And in certain cases, whether in relation to, let's say, the occupied Palestinian territory or other conflict-affected or contested regions, the EU's commitment to human rights may regrettably be perceived as inconsistent, jeopardizing its hard-won credibility as a global leader in this area. Addressing these challenges requires more than technical fixes. It requires political will, policy coherence, and genuine engagement with affected communities. The UNGPs are clear on this. Human rights due diligence must be ongoing and proportionate, and it must also be real. If implemented effectively, human rights-aligned trade agreements can deliver tangible benefits. They can enhance market access for responsible businesses, attract sustainable investment, and foster innovation. More importantly, they can help ensure that the benefits of trade are shared more equitably and that economic growth does not come at the expense of human dignity. As we look to the future of EU trade policy, the question is not whether human rights should be integrated. I should like to think that that debate has long been settled. The question really is how to ensure that commitments translate into practice and that the EU's economic partnerships contribute to a fairer, more just global economy. Trade agreements, when designed and implemented with human rights at their core, can be powerful tools for positive change. They can strengthen protections, empower communities, and reinforce the EU's role as a champion of responsible and sustainable business and trade. So the opportunity really is before us to make this vision into a reality, and to that end, the working group stands ready to provide support and to work collaboratively with all stakeholders. Thank you so much again for inviting us to be part of this conversation, and we very much look forward to hearing further the outcomes of the discussion.
Thank you so much. Yeah, you can hear me? Well. Thank you so much, Mrs. Yeopantong, for your valuable input, which highlighted again once more that trade is not only about exchange of goods, but it involves also people, and therefore it should never undermine human rights and should not be at all cost. And once again, we should reflect on how Europe, if wants to lead a sustainable trade, they should also ensure a commitment of human rights. And now we have finished with the speaking panelists, and we would go now to the Q&A session, which will be moderated by my colleague, Eduardo Melani. Thank you.
Thank you so much, Gloria. Then I will now open the Q&A session. So if you have any questions or comments you would like to share, please raise your hand. It will be a short Q&A session, so I will gather 2 or 3 questions and then let the speakers reply. So please feel free to raise your hand. Yes, please.
I'm not exactly sure to whom this question is meant for, but as the Ms. Anzizu mentioned, EU citizens are more and more engaged in human rights and care a lot about ethical trade and ethical supply chain. And I think the boycott initiative towards Israel is an example of this. So I was wondering, maybe towards the MEPs, whether the European Parliament feels these citizens' initiatives and whether this is taken into account, or if this is not strong enough yet to be taken into account. Thank you.
So I will let the floor to the MEPs before, and then to Ms. Anzizu.
Encourage people to continue to boycott, but also there is now the launch of the European Citizens Initiative on suspending the EU-Israel Association Agreement, and we're trying to collect the 1 million signatures for that. So if your country is involved in that initiative, I would encourage you to share that petition widely, and hopefully we will get the 1 million signatures, which again would send a very clear message to the European politicians that the citizens absolutely want them to act on Israel and the association agreement.
I think I can only agree with Lynn and say perhaps what my experience has been is that there has been so much mobilization, thankfully, for this issue, and it's something that often there are many invisible crises, and very much no one can argue that Gaza has been an invisible crisis. It has been on the headlines and people have been taken to the streets. And what I can say is that I really feel like that has increased the pressure and changed. So unlike Lynn, I came new into this parliament in June 2024, and I feel like the atmosphere of how my colleagues and how many people were present on discussions about Israel and Palestine and what kind of input they would give or what kind of position they would take would gradually get better and better as the time went by. And indeed there was this moment in the summer and early autumn in which it really looked like we were finally going to take action. And I think also Trump's peace plan nonsense complicated everything after that. But I really do think that it's a very good example of how I could see my colleagues shift based on their electorate and the people on the streets, and the fact that you just couldn't ignore this topic, and that's really important. Has it been enough? No, but it's also up to us, the politicians, to do more. And unfortunately for a lot of people, this continues to be a taboo or something that they think, they see differently from those of us who want to suspend the association agreement. But I would say it has played a crucial role in getting us as far as we've gotten.
Any other comments? Yes.
Maybe just a remark. I do not have insights on how this is being influencing within the EU, but I can tell you that in the context of international treaties, definitely when you're in closed-door meetings with foreign ministers, ministers of environment, the question that is being put in discussions, at least when I have been there, is what is going to be the headline tomorrow? How do we want to show up in the negotiations? So after, in particular in the context of investigative journalists and journalism more generally, how we're going to be appearing in tomorrow's headline. And that is something that I think is quite powerful because it has changed. Unfortunately, I would say unfortunately, it has made a difference on how some countries position themselves, in particular in the context of investigative journalists, saying like a specific country is not moving, not saying anything, or has been doing some things under the radars to maybe go through a direction that's at risk. And then this being shared through investigative journalism really has had a shift on how countries are scared, or those that are in the room are scared of taking specific or certain positions because they don't want to appear as to be doing something negative. Like the public opinion is being considered a lot, and I would say it's, in my experience, even more than protests, but really like journalists, and working with journalists is very important in that matter.
Thank you so much. So unfortunately, I have to close the Q&A session, and I will now leave the floor to Ms. Vieira for the closing remarks. Thank you.
Well, thank you very much. I hope this was insightful and useful for all of you. I'm not going to go very long. I just wanted to make sure that we touch upon the key points of the different panelists, to whom I really thank for all of your contributions. We started with Alan with great takeaways about how trade agreements can also be a push for certain countries to improve the situation. And for example, on the ratification of ILO conventions, we've seen actually positive movements arise from trade. And that one of the things that you mentioned that I think also stuck with us is that when it comes to human rights obligations, unfortunately, even if on paper, it also requires a great deal of political will. And I think this is something that we are seeing very much in practice if we speak about Israel and Palestine. In our trade agreements with Israel, is that it's not sufficient to have evidence that human rights abuses are ongoing. We also need to gather the political will, and that becomes harder and harder when there are other economic interests, alliances, and so on and so forth. So thank you for showing us how, yes, it's on paper, but it also isn't as simple as that. To Lynn, thank you very much for your contribution, and especially for your work over these years. I think we're can all be very inspired by the things you push. I think it's clear when you speak about the Western Sahara that the ECJ ruling was crucial, was important, but then the EU had a lot of shortcomings in its reaction to it. I also think it's very important, some of the points you made, when we see trade being linked with things that shouldn't be linked with trade. In the case you mentioned was humanitarian aid, which should remain completely independent. But I think we also see more and more this in another file, which has to do with migration and with the ability for countries to adjust their trade preferences based on whether or not the partner country is accepting migrants back that are sent away from the European Union. And this is a new development we're seeing here in the Parliament, in the Commission, in the Council, and I see with a lot of concern. When you make trade link with things that should stand on their own and rights that should be respected on their own. And I think the key message that you shared with us is that the double standards are actually something that will come back to bite us and to undermine us in the world stage as the European Union. Omar, thank you also very much for your... it's always different when you speak to someone who is representing directly the rights holders. To me, what came away from your message was that consultation does not equal consent, and I think that's a very important point. We have legal rules and legal definitions for these things, and we should uphold them. So thank you very much for your call for clarity as well when it comes to the need for our institutions to be as clear as the courts have been, much like Lynn had said. It's not necessarily the law that's failing, it's more our political response. Hélionor, thank you very much for a positive spin and a very optimistic, and I think it's really needed because we can forget that trade can and should be a vehicle of improvement, human rights, and not of harming them. And as you said, that the negotiation of trade agreements is also a key leverage moment for our partner countries, and now that the EU is putting out so many trade agreements at the same time and negotiating so many different things, we need to be very clear on where does this bring an opportunity to raise certain human rights issues, and how much are we willing to say, well, no, it's not good enough, or really encourage, really apply the pressure to make sure that this moment is pivotal in driving the human rights respect that we want to see. And finally, for Pichamon, first of all, from Australia, so thank you so much. I don't know what time it is there, but we really appreciate your effort. And we appreciate the work of the Working Group on Business and Human Rights. It is really crucial that you continue to uphold the UNGPs and bring back these concepts that I feel like right now are needed more than ever. Your intervention called for the EU to not race to the bottom on human rights in the name of competitiveness, which is something we agree with. Also, there are our special obligation to trade countries that are in conflict, and needs to remember that the EU works towards multilateralism rather than towards the latest narratives of weaponization of trade in the global stage, and then, as always, a reminder of the double standards and how much they undermine ourselves as well. I think our panelists said it all, so I don't need to say much. I think from the perspective of someone who's here at the European Parliament, the key words of this mandate, to me, economically and trade-wise, have been competitiveness and have been simplification. And I fear that competitiveness and simplification will not give us the long-term vision and the long-term results that we want the European Union to have. Not that I'm against competitiveness or simplification, but because it should never happen at the cost of other things that are more important, like our foundational values of the European Union and our coherence in the world stage, because when we want to say something and we want it to mean something, then we need to apply it across the board. And I think that's been very much the message of today. So I'd like to thank everyone. I'd like to give a special thanks to our panelists again, to ASSEDEL, who worked so hard, particularly to Gloria and to Eduardo for keeping us all on track. And thank you all for coming, and hope to see you in the future in discussions as this one, because I think they also energize us and remind us of the work we should be doing. So thank you so much.